Welcome back to Real Estate 101. Today we are going to talk about education law, and I'm pleased to be joined once again by John Schuman of Devery Smith Frank. John, welcome back to the show.
It's good to be here, Joe.
All right, John. So if you think your child has been suspended or expelled from school unfairly, is there anything you can do?
There's a lot you can do. In public school, there's a lot of rules and a lot of procedures dealing with suspension and expulsion, and they depend on whether your child's been suspended or expelled. In your private school system, it all depends on your contract. But your contract will set out what the rules are and when they can suspend and when they can expel. That's usually found in a code of conduct that's incorporated into the contract.
Okay.
And that code of conduct will say when we can expel, when we can suspend a student, and if there's a hearing process or not. If there's no hearing process allowed, then that's the contract you sign. You're stuck with it. But if there is a hearing process, then you can have a hearing as set out in your contract. If there is no hearing, then there's a sort of a principle of fundamental justice. Before your child gets booted out of their school, they should have a hearing before they do it.
Okay, so how are public schools different?
So in public school, there are a lot of rules for suspensions and expulsions. There's rules under the Education Act, there's rules under regulations under the Education Act, and there's rules in the board policies. And suspensions, even just suspensions, are for serious behavior, not just like not doing your homework or misbehaving in class. We're talking about serious things. We're talking things like doing extensive damage or vandalism to the school. We're talking about using drugs or alcohol while at school. We're talking about being insubordinate to a teacher, like seriously insubordinate to a teacher. We're talking about serious incidences of bullying. Those are the type of things that lead to suspensions. Things that are less than that probably are not suspendable offenses. And even if it is a suspendable offense, then a principal, before they suspend a student, has to consider what are called mitigating factors. Mitigating factors are things like the pupil's history in the school. Are they an exemplary student? Are they a bad student? Are they always in trouble? They're also supposed to consider things like, was the action in response to some sort of bullying or harassment or homophobic or racial type of slurs? Because that obviously is a mitigating factor as to why the student behaved the way they did. Have to consider a child's age as well. And those are just some of the things that can mitigate the seriousness of whether or not the action the student conducted, and can impact on whether the child should be suspended or for how long. And it's important to remember that even if a student is in a public school system, before they can be suspended, the activity that they did that was wrong has to be either at school or at a school-related activity. You can't just suspend a student for their behavior at home or in a park or other times. It has to be a school-related activity. And then you've got a series of rules that the principal has to follow when they suspend a student. It's not a simple or easy punishment, and it's something that the principals take seriously, and students and their parents should take seriously as well.
Okay, so what about expulsions?
So expulsions are much more serious. There are actually two types of expulsions. There's expulsion from just a school and expulsion from the entire board. But when we're talking about expulsions, we're talking about really very serious things. Principals cannot get rid of a student because they just don't like them. We're talking about things that usually lead to criminal charges. We're talking about trafficking drugs. We're talking about having weapons at school. We're talking about using weapons at school to cause harm to another student. We're talking about sexual assaults. We're talking about hate crimes, or what would be a hate crime, or hate behavior based on racism or homophobia that's designed to marginalize or hurt a student because of their identity. And we're also talking about things like repeated bullying, where the student was not corrected with suspension, and other forms of less coercive punishments have not worked. So when we're talking about expulsions, we're talking about the most serious of the types of offenses that can be committed at school. And again, they have to be committed at school or at a school-related activity. And when expulsion is so serious, it's a principal, him or herself, is not allowed to expel. A principal has to refer the matter of an expulsion to the board of trustees, and the board of trustees has to decide whether or not a student is expelled, either from his school or from the entire board.
Okay, but when kids are expelled from school, doesn't that mean they're out of school right away?
Yeah, so if a student commits an act for which expulsion may be a possible consequence, the principal is required to immediately suspend the student from school. And that's to allow the principal to do an investigation and to figure out whether or not the student should be expelled or not.
But what you're saying is that doesn't automatically mean that they're kicked out of school.
It doesn't mean they're automatically kicked out of school. It doesn't even actually automatically mean that they're going to be suspended. It depends on what the investigation
Right.
is. I mean, they're being suspended, they're not in school, but whether that goes on their record is a different thing.
Different story, right?
And the principal only has 20 days, well, it has less than 20 days because the school board has to have their hearing. The board has to hear and decide whether or not the student should be expelled within 20 days of that notice going out. Otherwise, they cannot expel the student anymore. They can't even impose some punishment on the student because the time has expired. The exception to that is when a principal and the parents agree that the student will be expelled, and they sign an agreement that the student will be expelled. But that's something that parents should probably never do without speaking to a lawyer first, because, as I said, expulsions are not only serious punishments, but the things you have to do to get expelled are serious, and you have to consider the mitigating factors again. And there's a lot of things to consider about whether a student should be expelled. And if the principal hasn't considered all of them, chances are the student should not be expelled. And to know whether your child should be expelled or not, you really do need to speak to a lawyer who knows the Education Act and all the regulations underneath it.
Okay, so let's talk about these hearings. You've obviously been in on these.
Yeah.
What are they like?
So they actually look a lot like a trial, except that you're doing it before either the entire board as a judge or a committee of the board of at least 3 members. But you have actual witnesses at these hearings. So people, go stand behind a table or sit behind a table, and they give evidence as to what happened.
Really?
Yeah. So then the principal usually has a lawyer at these hearings, and the parents are entitled to have a lawyer at those hearings, and so is the student. And if you can't afford a lawyer, you can contact Pro Bono Law Ontario because they can help fund litigation the hearing process. And also, in some circumstances, legal aid will help with the hearing.
Say,
yeah,
legal aid is also in this stuff too, eh?
Yes, and if you can't go into those, but you can you obviously hire a lawyer privately to do
Right.
it. And because expulsion is like not only a serious punishment, but also can have serious long-term effects on a kid because it goes on their record.
Right.
So you may want to have a lawyer there, and you also have to know, and this is important. Before you go to that hearing, it's sort of like criminal law because it's such a serious punishment. You are entitled to disclosure from the school. So you're allowed to see everything they have to use against the student, your son or daughter. And you're also allowed to see everything they have about your son or daughter that may not support the suspension or the expulsion because, as I said, there's mitigating factors. And the school board's not allowed to hide things that would suggest there's a mitigating factor that would lead to a child not being expelled. If they do that, then the whole case will fall apart for them.
All right, so the hearing's been conducted. What can the board do at the end of the hearing?
So the hearing, the board has basically, sort of 4 options. The board can decide that nothing should be done. And sometimes that is the case, that the principal had it all wrong. And
So nothing meaning the kid can go back to school?
Kid can go back to school, and there's no record of a suspension or expulsion on his record. The school board can also decide the child should just have been suspended and set the number of days the child should have been suspended because it's more like a suspension offense than an expulsion offense.
Right.
And the school can also recommend that a child be expelled from just the school, which means they can attend another school in the board, or they can they can be expelled from the entire board, which means they cannot go to a regular school in the board. They have to go to like a special expelled students program.
All right, so what if the student or parents disagree with the board's decision to expel?
So if a student's been expelled from either a school or the board, the student or the parents have an automatic right of appeal to what's called the Child and Family Services Review Board in Ontario. And the Child and Family Services Review Board it's a lot like a court, except that instead of having judges, it has tribunal members who are specialized in hearing education law matters. And so they know all about expulsions and suspensions and what the law is and when a child should be expelled and what the procedures are. And because they are so specialized, they can review what the school board did. They often hold another trial, the same thing with witnesses and people cross-examining and making arguments. but they do it in a much more formal way and a much more lengthy way. A expulsion hearing can be a couple hours. A review board hearing can be weeks, if the case is serious enough, and they will review the school board's decision, and they can reverse the school board's decision and say that the student should not be expelled, should not have any record even of the expulsion, if that's their decision. They can also confirm an expulsion, of course.
Right.
But they take a very careful look at what the school board did, and they are probably more careful about making sure boards follow the rules than even the board is. So if you have a child who's been expelled and you think it was unfair, you should go and appeal to Child Family Services Review Board, because they will look at it very carefully and in a way that is very, maybe not sympathetic to the student, but considers the student's rights as being paramount.
All right. So does the record of a student being suspended or expelled, does that stay on their record?
It can, yes. So
forever?
Forever. So the record of a suspension or expulsion goes in what's called the Ontario School Record, and that follows a student wherever they go during their elementary and secondary school careers. So every other school they go to will know about the suspension or expulsion. However, a principal has the right to take out of the Ontario School Record documents that they think should not be in there, that are unduly prejudicial or do not reflect the student or are just improper. So parents can ask a principal to remove a record of suspension or expulsion if it's clearly no longer appropriate. So if you have a child who's been who was suspended or even expelled when they were younger and has shown no behavior problems for a number of years, then the principal may decide, no, this is not fair to have, this student is clearly reformed, it's only prejudicial, it doesn't help the student at all to have this record, so the principal can remove it. There's, in a number of boards, there's procedures that principals have to follow and parents have to follow to ask a principal to do that, but it is possible to have that record removed. Although in the cases of violent offenses, then there are actually time periods before a principal is allowed to remove records, and that can be up to 5 years in the case of more violent offenses. The principal is not allowed to consider removing anything from the record for that period of time.
All right, so let's say the principal can't meet the legal test. We'll say that of getting the kid out of the school, but still wants to get the kid out of school. Is there anything the principal can do?
No. School is a right in Ontario. Every child in Ontario has a right to publicly funded education. They cannot be kicked out of school and denied a fundamental right of education. It's even under the UN Convention of Rights of the Child that children have a right to an education. So you cannot deprive a child of their education except by following the procedure for suspension or expulsion. Now, that doesn't mean sometimes principals don't try.
Right.
I mean, there's this procedure called an exclusion, where a principal is allowed to exclude people from a school. And that's basically giving the person a trespass notice and saying, don't come back into the school. And it used to be that, principals who couldn't get a kid expelled would just exclude them from school.
They would use this loophole?
They would use this loophole. But in about 2009, the Ontario government passed a regulation that said you cannot exclude a student from the school in which they are enrolled. So a principal cannot get a student out of their school by using the exclusion power. They have to suspend or expel them. Another trick that principals sometimes used to use was that they would try to transfer or have the child transferred to another school. So move the child away from that school because they didn't want them there anymore. There is some, merit to doing that when, there's some serious conflict between two students and there's always going to be a problem at the school. But you cannot move a student from one school to another without identifying that there being some special need to do that. And that usually involves that student being identified as an exceptional pupil, a student having special needs and having needs that have to be accommodated that cannot be accommodated within the school. And there's a process for identifying a student, and there's a process for placing a student. And it's called an IPRC process, but parents are allowed to participate in that process, and they're allowed to appeal that process, first within the board and then to the Special Education Appeals Tribunal. So you cannot, a principal cannot just boot a kid out of their school without having it reviewed by somebody else.
All right, John. So what should parents know if their kids get into serious trouble in school?
Well, if your child has been suspended or expelled, It's always a good time to speak to a lawyer because it can be a permanent record that can impair their ability throughout what programs they can do while they're in their elementary and secondary school career, and they may have to report it to when they apply to college or university.
I was going to say, right?
Yeah. So that can be serious for your child. And there are so many rules that the board has to follow, and really, suspensions or expulsions are only for the most serious things. So if it seems like it wasn't that serious, it probably wasn't a suspended or expellable offense. So you should speak to a lawyer and find out what your rights are. Most parents don't know what their rights are. Most parents sign because they're told to sign and give up their rights to a hearing. And really, they should never do that. They should find out, even if they don't speak to a lawyer, either speak to Pro Bono Law Ontario or look at the Education Act and see whether your child did something that qualifies for those things and whether or not there is any mitigating factors that apply or whether the school has even followed the rules for suspensions and expulsions. Because if they didn't, your child should not be suspended or expelled, and they should not have that record.
All right, John. So for people watching and listening who may want to get in touch, how can they reach you?
Well, they can call me at 416-446-5080. They can email me, and you can find my email on our website, which is www.devrylaw.ca. They can follow me on Facebook, on my Facebook page. They can also follow me on Twitter at @SchumanFamLaw, and they can find me on LinkedIn.
All right, John, great stuff. Thanks for coming on today's show.
Thanks for having me, Joe.
So there you have it. If you're looking for more information on education law, get in contact with John Schuman of Devery Smith Frank. Don't forget to subscribe to our YouTube channel, like, comment, and share our videos. I'm Joe. Thanks for watching, and we'll see you next time.